Good morning, afternoon, whatever it may happen to be. This is, of course, Jim Lampert again, and this is the question and answer session after the third of our lectures. As usual, we have a lot of really very good questions. And one of the things, having gone over these, that I think we want to keep in mind, and I'll get back into them in more or less detail, depending on what question we're dealing with, is this basic idea: why do you want a patent anyway? What is it going to do for you? What might it not do for you? Because a lot of people always want to know, how do I get a patent? But it's very clear you have to think about why you want one if you're going to make that investment worthwhile. As I've done in the last few weeks, I've tried to break the question down into sort of different subjects groupings. And there are about 4 of them that are here today. First one is really what people are worried about is prior art. What am I going to do? What might someone else do that either invalidates or puts a great big hole into my patent protection? And the starting question is really a good one. It's the problem of clinical trials that obviously you can't do completely in-house, at least not at the level that approval agencies like the FDA is going to require. And the underlying problem is not limited to clinical trials. It extends, as I think we may have mentioned a couple of weeks ago, to any time when you don't have the ability to test something or make something in-house. When are you going to have to go outside? And if you do, what risk are you running that what you are doing will be read by a court later, or maybe by a patent office when you tell them about it, because you're supposed to tell them about all the relevant prior art things you've done, that might be disqualifying. Clinical trials, there are really kind of 2 ways to look at them. If you're on the side of the patentee or the applicant for a patent who is trying to make sure that they don't disqualify. Do they amount to a public use? Can you argue that they're experimental? We didn't have time to get very deeply into the experimental last time, but if you read a lot of cases, and I'm sure you all are just waiting for the opportunity to ruin your lives doing so, you'll find that it is very difficult to prove that something is truly an experimental use. The same thing is true if you're trying to prove something is an experimental sale. For example, the sale of any of the things you're testing to the doctors or the groups that are going to do the clinical testing. There was a case in the US a few years ago that gave you a much better argument, perhaps, to say, hey, these aren't public uses at all. They tried to put enough confidentiality around them. They had people who were running the trials sign confidentiality agreements. In some cases, people try to work those into the consent form that you give people who are participating in the trial. But if you can put it under a confidentiality umbrella, you can probably avoid the question of whether this is or a public use, which means that if it's not a public use, it's not prior art to you. At least in the US, recognize that some foreign countries may look at the situation a little different. The rules as they are applied in Europe, in some instances, as I recall, are a lot more stringent in the US in terms of what you really have to do to make sure that something remains secret. Your practical problem when you get into clinical trials, or if you have somebody else manufacturing for you, or if you have somebody else testing for you, is can you really keep it secret? Because even if you keep it secret enough so it doesn't upset your potential patent, can you keep it secret enough so that other people won't really know what you're doing and won't be able to largely copy what you're doing unless you somehow are lucky enough to get into a patent or get a patent that will basically bar them later? What about prior art? What's an assessment of prior art? I wasn't quite clear what this means, but let's take a dive into it anyway. You need to sort prior art questions into two time frames. When you're in front of the patent office and after the patent issues. When you're before the patent office, the examiner is going to find very, very little of what is potentially prior art. The examiner has at best a few hours total, start to finish, to deal with your patent application. That doesn't leave a great deal of time for her to dive deeply into what is the prior art, to run a really complete search. And if, as often happens, people bury the examiner in piles of prior art, even to read them. On the other hand, that prior art usually will be found, or an awful lot of it will be found, after the patent issues, if you're in litigation trying to enforce your patent, or if you're trying to, in negotiations, get a pretty high royalty out of it. People who have a reason to want to say, hey, your patent is or probably is invalid, it ain't worth as much as you're asking, are going to spend more time and money than any patent examiner does. As a practical matter, what are the major sources of prior art? It all comes down to what's most easily findable. Patents are probably the best prior art. I saw some statistics over the weekend where they are far and away more patents are cited in litigation as prior art successfully than any other type of prior art. Second in line is going to be technical publications, because a lot of those don't make it into patents, or they frankly may be in a lot more detail and really tell you what was going on than the patent does. And finally, there's the type of thing that the patent office just can't look at at all, and that's the real world. What were people actually doing out there? It's harder for someone trying to invalidate your patent to find, but there is always a lot of it, particularly when you realize that the test now is not was it done or sold in the US, but was it done or sold anywhere in the world? What types of claims don't hold up in litigation? I can be facetious and say bad ones and too broad ones. But beyond that, there are a lot now that run into problems, particularly in the software area, under this what's patentable subject matter, as we talked about last time. Software, many challenges are made, many are successful. But one thing to keep in mind is only a very small percentage of patents ever gets into litigation. It's probably less than 2%. The important thing for you, if you're running your business and trying to convince people to invest in you, is to get that patent and get one that you can hopefully make a pretty good pitch as to why it's important and valid, because 98 out of 100 times, you're never going to have to defend it in court. When you do have to defend something, and this question goes really focused more on during examination, what do you do if an examiner takes a position that frankly goes too far? Remember, they don't have much time. Examiners often will take positions that when you look at them hard and you look at the prior art hard, really try to go too far. If the examiner finds something that's only similar to what you're doing, that word similar should tell you that he can't say that you're not novel. Because to fail the novelty test, to be what people are called anticipated, you have to find every single bit and piece in your claim in a single piece of prior art, in a single prior patent, in a single article, in a single process that somebody else used. How do you attack this when the examiner goes overboard? You look at the piece of prior art that she cited, and you go through it, and one by one, you compare what is in your claim, and you point out to the examiner why it was wrong in saying that this piece of prior art really teaches it. And that will go a long way toward also convincing the examiner that what you've done is not obvious, because if you've taken away the examiner's factual basis on what a piece of prior art shows, It's an awful lot easier to say, how can you say it's obvious to do something when this prior art, none of the prior art even teaches it? Claims. The patent lawyer's sonnet. Totally unreadable. If you've read a few, totally punctuated in a way that no teacher would ever let you get away with. They're all one sentence long, one period at the end, and God knows how many hyphens, semicolons, or commas running through the middle. Broad versus specific. What do you want? If you're a patentee, in terms of covering the marketplace, you obviously want a broad claim. As we talked about probably in the first lecture, a claim that covers only what you're doing may have very little value because many times, and the exception is probably in particular chemicals in particular parts of the bio world, but for those exceptions, there are a lot of ways to accomplish basically what you're doing in a slightly different way. For your claim to be valuable, you don't want it to be too specific. If it only covers what you're doing, unless the technology is such that someone has to precisely copy you, the claim has really very little value. If, on the other hand, it's broad enough so it covers what people will have to do, even if they make minor variations in the overall product and the overall process, then it has real value. But of course, there's another side of the coin. The broader a claim is, the more prior art comes into play, and the easier it is for somebody else to prove the claim's invalid. Because if you don't have a lot of the specifics in it, it means the prior art doesn't have to have those specifics either. The more specific you get, the more difficult it is for someone else to find prior art that might invalidate your claim. So like everything else, or most other things in this field, it comes down to a balance. How do you balance having a claim that's broad enough to give you real protection competitively in the marketplace, and at the same time being sure that it's narrow enough so first, the examiner will allow it, which is the obvious first step, and second, so if it ever does get challenged later, you have a decent chance of success. You'll learn a lot of this in the course of prosecution, course of getting your patent, not only in the US, but abroad where patent examiners will also find prior art. You're never going to have the specific answers of exactly where should you be. So what do? One thing you do is you write claims of varying breadth. You have broad ones, and you also have more specific ones. Because if the broad ones fail on validity, the specific ones are still there. And if the specific ones aren't infringed, you may have a broad one that is. Which kind of leads us to the next question, is how do you prevent loopholes in a patent? So somebody can slightly modify what you come up with, what you're doing, and use it and be outside of the patent. Let's make a starting assumption, but somehow you've gotten past the problem that this is a, quote, algorithm, close quote. Because algorithms are always on the list anytime anyone makes a list of things the US Supreme Court says aren't patentable. On the other hand, if you simply add a computer to an algorithm, the rules in much of the rest of the world, and Europe is the best example, is different. So the fact that something isn't patentable here, as I hope I mentioned last time, does not mean it might not well be patentable in some other rather big countries. So how do you prevent loopholes? You don't get too specific. You write a claim that focuses on what's really the core. What is anybody going to have to do to get the benefit of what I really came up with? And you stop there, at least on your broadest claims. If you have to put more details later, go ahead, just like we talked on broad and specific a moment ago. But if you have included everything that has to be done to use your broader than the specific algorithm itself invention, nobody can simply modify a piece of what you claimed, namely the algorithm stated broadly, not narrowly, and go ahead and skirt you. Third question raises a somewhat different situation. There are a couple of scenarios here. The basic question is, what if claim 1 says something has to be wood and claim 2 says it should be metal or plastic? Are these independent claims or are they dependent claims? You'll remember from the first lecture, the patent we put up had both an independent claim and a dependent claim in it. And I hope I remembered to say that when you're looking at these, the independent claim stands alone, but the dependent claim narrows it. Well, if an independent claim says something's wood, you certainly don't narrow that if 7 is dependent by saying it's metal or plastic. What you'd have to do if that independent claim say it has a hard material. Claim 2 would say it's wood. Claim 7 might say the thing of claim 1 where it's metal. Claim 8, the thing of claim 1 where it's plastic. So you could start out with a generic statement and then put in all the specifics. But if on the other hand, if claim 1 says wood and claim 7 says metal, claim 7 is going to be invalid because a dependent claim can't contradict what's in another one. What you can do, though, is have 2 independent claims. Independent claim 1 says the thing you're sitting on is made of wood. Claim number 2 says what you're sitting on is made of metal or plastic. Since they're both independent, there's no longer any conflict in the claims, so both are potentially good and valuable. But you can't start with wood and narrow it to plastic at a different claim. Updating claims. This is a very big practical problem for you if you're trying to run a company or put out product. Most of the time, you are going to find that what you really thought was important at day 1 may not be what you think it is 2 years down the pike. So if you fought and got a lot of claims that covered the particular thing you were doing at claim 1 in day 1, what are you going to do as you learn going forward? And the whole patent process is going forward too. So you have protection for what the real product's going to be, for what you found out was really important. You can't update a claim once it's in a patent that's already issued. Let's start off right there. If your patent is issued and it's let's go back one. Let's say your patent claims a chair made of wood. You can't change that claim in the issued patent to say, oh, I really wanted to say a chair made having a hard seat. It's frozen the day it issues. What you can do is try to keep a chain of applications going. So even though your wood claim has issued, and maybe it's because the only thing the patent office would give you initially, you've got another application back there that says the chair has a hard seat, or maybe you filed a new application that brings in the fact that it's metal or plastic. The key here is if you want to go from wood to hard, your early application, wood will support a claim to hard, because wood typically is hard. Wood will not support a claim, so you'd get the priority date of your first application. If you simply continue refiling the same application and keep trying to get broader claims, you may get later patents that are broader than you had initially. If, on the other hand, you've discovered the chair has to be plastic, and you don't have plastic in that initial application, you're going to have to file a new application. And you're going to have to file an application that specifically discloses plastic and probably says why plastic is so good. That new application has a priority date of the day it's filed, which means unlike the first one, anything that falls in the gap between those two dates is prior art. So you have to be careful how you're updating. Your early application may be prior art to your second. So somebody asked the question, gee, if it's prior art to make a chair out of wood, is it obvious to make it out of plastic? And that question will be asked if your first one's prior art. If, on the other hand, your first one said wood and your second one said hard, nobody can say, hey, the prior art shows wood, because there isn't any wood prior art. Your early application is not prior art to you. Confusing from the looks on the table across from me? Yes. But what it really comes down to is two things. First off, you can't broaden a claim once it issues. If you don't like the claim you got in a patent that issued, as long as you have kept an application pending, you can go back and fight with the examiner again to try to get broader language. And if you need really to add something new, you're going to have to file a new application, but that's going to raise new prior art questions. Now we're back into good old patentable subject matter. How did patent protection change after Alice? Unfortunately, there's more history here than any of you really wanted to know. Alice was the fourth in a chain of US Supreme Court cases dealing with patentable subject matter. The first one dealt with software. And that the case is named Bilski for anybody who wants to read it. The big fight in that case, beyond the fact as it was a patentable subject matter, was did its decision apply only to software cases and only to processes? And that question was not answered in Bilski. Bilski, the real fight in the Supreme Court was whether business method patents were allowable, period. It was a 5-4 decision. The 4, clearly until the last minute, people thought it was going to be the 5. But they lost a judge. And that would have said business methods were unpatentable, period. The end-up majority said, oh, you may find business methods patentable, but only in some cases. So after Alice, you've got this great big question of, okay, Bilski's software-assisted business method claim was not patentable, but how broadly does that rule of law apply? Not answered. And a lot of people really said it's only software and it's only processes. Then the next two cases were both in the bio world. They were Mayo and Myriad. The BRCA gene discovery. This, remember, is the gene that basically is a marker for breast cancer. And the discovery of how much of something should be in your blood. So, gee, let's measure the blood. If you need more, give you more. If not, make sure you don't add any more as time goes on. Both of those were also held not patentable. And frankly, the first of the two had a pretty good decision in it. But they were all focused on laws of nature, which is very different than what Bilski was, which was a software case. So then along comes Alice, which is another software case. But the important thing it did was say at least two things. First, this unpatentable subject matter idea is not limited to process claims. It can be a product claim, it can be a machine claim, you name it, as long as I'm going to use a bad word that any patent lawyer would shoot me for, as long as the heart of that claim, the heart of the discovery, is an abstract idea to which you've eventually added nothing, or something that already existed in nature. And the second thing they said is you use the same analysis across the board. And that was the analysis that we talked about, I believe, a couple of weeks ago, which say you first look and see, is the claim directed to a law of nature, an abstract idea? And they then ask, does it, if so, does it add anything of inventive concept of enough significance to it to move it out of the forbidden category into the new? What's the result? There haven't been many biochemical cases since. There have been a couple, and the Federal Circuit clearly doesn't like the result, but it is quite clear that it's largely, gee, for a change should follow what the Supreme Court tells it to, and they've held some invalid. There have been a lot of decisions that have gone into the software world in both processes and others where it said these are the abstract ideas, and what the claim adds to the basically abstract do it with software idea is not enough to make it valid. So the real change after Alice in the real world has been a lot more software patent cases where patents have been held invalid at the Federal Circuit, and frankly also at district courts. Only a few more in the bio area. And hopefully, sometimes people are going to straighten out and decide exactly what additional you do have to add, but nobody's decided that yet. Can startups like Uber, well, I typed a not, and I don't know whether that was in the original question or whether the original question was now, but so either way. So I'll take it as now and assume it's by typing. Can they now patent a business model? If you're Uber, what are the potential things you might try to patent? The idea of having a lot of freelance drivers who own their own cars coming to pick you up, cleaner car and probably cheaper than a cab. That ideas by themselves aren't patentable. What might be patentable? Well, you know darn well that Uber has spent a great deal of time and money developing the programs that get the right car to the right place at the right time, know how many are out there, know where they all are, et cetera. There very likely is something in those programs, in that whole computer setup that might well be patentable. The idea that you have to get the car to the right place is one thing. The idea that a computer can do it faster than a paper and pencil can is one. But what do you have to do to the computer itself to do that efficiently? Because the minute you start doing things to the computer itself, as you recall, you moved into the area where the Federal Circuit will now think about giving you a patent. In other countries, well, let's go to Europe. They say the computer programs per se, ideas are not going to be patentable per se anywhere. But what do you have to add to that software to make it patentable? In Europe, simply adding a computer is typically enough. And that's a big market. Look at all the fights over Uber that are going on in Western Europe right now. It's also enough in a number of other countries. We, at the moment, are tougher on what you have to add to software to get a patent than a lot of the rest of the world is. Finally, we have the 300% faster algorithm. I'll take the easy part of this first. Unfortunately, there's no such thing as an international patent. You eventually have to go country by country. Europe has been struggling for a number of years to come up with a patent. Remember, they already can examine them in a central office, the European Patent Office, but you then have to take the patent down to each of the countries and get individual patents in each country. And typically they grant the same patent at the EPO, but you still have to go country by country in your patent. They've been trying to come up with a European patent. Ego is such that it hasn't worked. You haven't been able to get all the countries to agree because they all want to have their own little thing they can do with patents. It may not be what every other country is willing to do. So there are no international patents. You do have to go country by country. And there are various ways to do that that we're going to get to in a couple of minutes. Now, as I said a few minutes ago, algorithms, as you remember, at least in this country, are on the Supreme Court list of things you can't patent. But the other question is, the person who asked this question, are we really talking only about the algorithm, or are we talking about something more? Something more than simply a bare sequence of steps that you would do to accomplish something. The minute you can move it into the something more, you also have a chance in this country. Don't ask me exactly how much more that has to be because nobody knows, no patent lawyer, and certainly not any of the courts. Getting a patent. I get asked the first question almost every time I lecture in a business school or an engineering school by a student, postdoc, or somebody who's trying to do something. It's tough. The first thing to remember, and this guy did, whoever put the question in did, is remember there is other IP. Can you get a modicum of protection on the copyright route? It's going to be less, and we went into ways in which it's less earlier. How much are you going to be able to protect through trade secrets? How much might you be able to protect simply by agreements with the people with whom you're working, and frankly, by being very careful how much you disclose, one of the problems being often what you sell discloses a lot more than you wish it did. On patents, it's really hard. Most patent attorneys don't write patent applications without getting paid. Lawyers who deal with full companies being founded are far more likely to give you a discounted rate at the front end because they really hope to get all of the company's business as it comes in later. Unfortunately, from the patent attorney's point of view, once that patent application, that core one that has your whole idea is finished, you have no idea whether there's going to be any additional information. One thing you can do, remember the provisional patent application? You can always file a provisional application. How much it's going to cost you to file it is really going to be in time. How good an application is it? The cover sheet on a paper that you are about to give tomorrow is probably about the worst. Some provisional applications are full-fledged patent applications written by a lawyer. That's not going to be any cheaper. But if you can get a provisional that will give you some protection going forward, it at least buys you an extra year to find out whether your market and your investment potentials are such that it's worth spending the larger money. I could talk, I've got 26 minutes to go, and I could spend most of that talking about PCTs, but I'm not going to. PCTs are a big deal. The real reason for a PCT, the basic thing it's supposed to do, going back to when it came into being, was to give you time, more time than, let me step back for a second. Before the PCT world, you'd file a patent in a country. And you then had 1 year under what is known as the Paris Convention to file that same application in any other country you wanted to. But it was only 1 year, which often was not very long. PCT is designed to give you more time. In the PCT, you can get about 2.5 years total time by the time from your first application to when you have to decide, where am I really going to file in different countries? Because when you file a PCT application and you have to do so within a year of your first, that hasn't changed. But all you do is list all the countries you might want to go to later. And you have another year and a half to actually decide whether to go there. What do you get for that other year and a half? If you're lucky, you may get an office action in the US, which assumes where you started. I assume that's where you started. And it may tell you what the prior art that you didn't know about looks like, which can drastically affect your decision on how many countries am I really going to file in, how much am I going to fight this, how much am I likely to really get. The PCT people give you their international search report fairly quickly after you filed. So you hopefully will have that more information also. But what a PCT can do for you is give you information you did not have before about what the real prior art looks like. And frankly, the PCT and the US examiner will also tell you what they think of it, whether they're going to reject all your claims or not. So you can sit back, swallow, ask yourself, is this patent going to go anywhere? And since you're also maybe a year and a half down the road, you can also ask yourself, is this the patent that I really want? Or have I changed what I think is important? So I ought to think about something else. But it buys you time. You can get a quick patent out of the US. There's a so-called, I guess it's track 1. They'll guarantee you a patent or try to within a year. You may get a first office action, response from the examiner within 4 months, but it costs you $4 grand, and the patent office only takes 10,000 of them a year. You can spend the same amount of money and file a PCT and get about the same thing. There are advantages and disadvantages at all kinds of levels on each way. If you really want to decide to go PCT versus US application, get all your ducks together, realize exactly where you want to go, and then sit down with somebody and work through all the permutations and combinations. An awful lot of people are voting PCT these days. And the way they actually do it, if you're in the US to start off with, is they will file a US provisional application. And their next application, instead of being a US application, will be a PCT application that designates the US. That leaves a lot of options open, but it also costs more than simply filing an application. Though, always remember that you will probably pay your patent lawyer more to write the application than you're ever going to pay a patent office for the filing fee. Are there problems with PCTs? Yep. Next question brings up one. You can't file a PCT in Pakistan. There may be 100 or 150 countries that are part of the PCT grouping. Pakistan doesn't happen to be one of them. So what do you do if you want a patent in Pakistan? You have to file there. If you're from Pakistan and want a patent in the US, you can certainly file a US patent. There's no limit on citizenship for who can file and who can't file in the US. You may decide, if you can do it, I'd have to check with a PCT expert, to file a PCT application. Starting off, you may just want to file a US provisional. Are you going to want something that eventually covers Pakistan? That depends on market. You may decide it's worth it, you may decide it's not. Is there any manufacturer there? Is a big enough market to justify what will be the cost? The question you ask for any country in which you're trying to decide whether I want a patent. If you start off with a US application, remember I said you could simply file a PCT next and then get 30 months? Not in Pakistan. You're going to have to file both the PCT application to cover the rest of the world, and you're going to have to file directly into Pakistan. And there are a few other countries of which that is true. It raises expenses, it raises timing issues that can be really tricky to keep track of. Taiwan, at least as of the time I retired, was another one that was on this. We're not PCT members. So you have to figure out how to be able to file in both Pakistan and Taiwan directly from a US application, and maybe PCT for the rest of the world. And one of the things that comes into this is the US, if you're a US citizen, and maybe also the inventions are made here, has what's called, you need a license, because the US does not like to export security types of technology. You got to get that license. Well, this really follows on to the last question, is how a patent could help in some poor places. I guess the question I'm going to ask, and ask you to think about, is help what? Are you trying to help sales in those poor places? Are you trying to have product that will help people in those poor places? Are you trying to help you protect, using patents, a market in those places? If all you're trying to do is sell product because something that's cheap and will purify water is really important in a lot of countries like India and many, many places in Africa. And it's important at a good price for reasons that have utterly nothing to do with patents. But it's very helpful to the people there. Why do you want the patent? Do you ever expect to sue anybody there? Do you expect to have a patent in each of the Latin American countries, or in Pakistan for that matter, if we step back one? Is what you spend on a patent going to be something that gives you a decent return on your investment, other than perhaps marketing? Do other people's have patents where, at least if you have yours, it might help you be able to sell there without running into their patents? Though if they have patents in Pakistan or in Latin America, the chances are they also have patents in a lot of the rest of the world. So your cross-license picture, you can use mine, I can use yours, is probably going to be a much more global discussion than simply country by country. Start to place off with your patent is, why do you want it? Your goal is to be able to sell product. Unless a patent is somehow going to help you sell product, why spend the money on it? Maybe the product is a very good one and very helpful and very important, but there are a lot of other ways to develop the market if a patent on this isn't going to do you a whole heck of a lot of good or make a whole heck of a lot of progress. And I think, believe it or not, that we've now basically made it through the list of questions. So I'm going to turn to Andrew and ask him what else has come in.
Good morning. Jim, thank you for sharing your thoughts on the questions. We have questions from a few of the attendees today. If you do have questions, they're going to be answered in priority sequence, so please go ahead and send in your questions right now. So the first question comes from San Bao, and this person is asking, does a patent invention need to be put into practice? And if so, at what time frame? And is this during the invention or at a later time?
The simple answer is no. You don't have to actually do something to get a patent. You can get a patent on something that is purely on paper, provided the paper tells people enough so that they, quote, could make and use it and know how to do it. 150 years ago, the patent office used to require a model of everything you were trying to patent. They gave up. The only models they now require are for perpetual motion machines. They don't get many. But it's been very clear, there's case law in the US going back a long way, and I think it's the same. I don't know of any place else in the world that it's different, that says you don't have to practice your invention to get a patent on it. Whether you practice your invention may have an impact farther down the route, If you find somebody is infringing your patent and you sue them, what you typically sue for, what a patentee typically wants, is both money and an injunction, an order that tells the other person to stop what they're doing. If you don't practice, in the US today, it is very difficult typically to get an injunction. You'll get your money, but unless you've got something that you make it use, or frankly, to put it more into what's a typical MIT type of context, that an MIT licensee is making and using, somebody who's closely tied to the patent, you probably won't get an injunction, you will get your money. But the bottom line to your first question is no, you don't need to practice. You don't even need a licensee who practices.
Great. And the next question from Otto. Can you elaborate further on business method patents? What are they and when are they useful?
I can give you, let me give you two cases, assuming I can remember the facts, that the Supreme Court looked at. The first one I mentioned today was the Bielski case. Bielski dealt with a situation where people were buying and selling oil for the heating oil market. And they wanted to be able to hedge against prices either going up or prices going down. Well, I assume any good MBA financier can tell you what you have to do to hedge, and how you hedge it is clearly a business method. It's how do you practice run your business to avoid the problem of prices going too far in one direction or another, and you either getting filthy rich, which is fine, or getting murdered, which isn't what you had in mind. And Bielski said that that is a business method. And since all they did was tell you to use a computer to do it, it was not patentable subject matter. Second case, where it all came from, was the State Street Bank case, which was spoken wheel financing, keeping track of all the investments on a daily basis as they ran in and out. They're out in the periphery of the wheel. State Street Bank had a really good financial system for keeping track of all of this, a way of doing business. Federal Circuit allowed that patent, which led to the blossoming of all kinds of financial world, which is really where most of the business stuff comes from, financial world types of patents, until you got to Bielski and then later Alice, where the Supreme Court said, who are you kidding? Alice, the most recent case, had a situation where you've got two people who are buying and selling, presumably both of them involved in this, and each either being owed or owing money, depending on what they bought and sold and for how much. And they don't trust each other. So what do? They hire me, because of course I'm completely trustworthy, to hold all of the money until the end of the day, the trusted third-party intermediary, and then pass it out. A way to protect your business. That's the type of thing that you're talking about as business patents. The business method patent is simply, gee, you know, if I let people charge stuff to their credit card, that's a good way to run a business. If I am Amazon, one click is a good way to run a business. That patent got upheld early. Query what it would do if it came up again today. There are all kinds of business ideas, most of which people have tried to patent simply by saying, do it on a computer because it's faster. And those are the ones that are not getting past muster, either in the patent office or in the courts today. I hope that's the answer.
And Giovanni is asking if you can provide an example of a broad as well as detailed claims, and if you have any practical rules that you've used to make them either more broad or either more specific.
I'm going to make one up just to make it more fun for both me and Giovanni. And actually, what I'm going to I'm going to go back to this wood and plastic a little earlier. The example would be, you're going to see this for the next session, a chair. And a chair has a seat. Suppose you're early enough in history, so that's really new and not obvious. A broad claim would simply say a sitting or place to sit having a surface spaced above the ground. Of course, that reads on a rock, so you may have trouble with it. Nice broad claim. It covers anything you ever would want to sit on, but it would cover any chair up to and including all of the expensive desk chairs that are being sold today. But it very likely may be invalid because of the rock, or because somebody will take the position of, who the hell are you kidding? This has to be obvious. As that claim gets narrower, you could say the chair has to have a wooden seat. It has to have a plastic seat. It has to have a seat that lights up when you sit on it. It has to have a seat that's enough of a pillow on it so you won't get stiff if you sit on it for too long. All of those cover less. They open you to more competition, but they have a greater chance of perhaps being not obvious. What holds the chair up? Simple stool can have 3 legs. You look at the support structure for your adjustable and God knows how many different ways desk chair, it's a lot more complicated. The specific claim to a desk chair, a new one, would have up and down mechanisms, it would have tilt mechanisms in at least 2 different directions. The arms probably move around. Those get narrower and narrower claims. They cover less and less. What they cover are still important products and important markets, but they're a lot narrower market than anything you can sit on. Hopefully helpful.
And we have another question from anonymous attendee for patent applications that are denied. Is the information about why the application is denied shared? And if it is it in the public domain easily accessible by anyone?
Okay. If it's denied, and I'm going to assume the US practice at the moment, when you file your US patent application, and forget about the provisional application, nobody ever looks at it, just sits in the patent office. When you file the real one within a year, you will have all kinds of backs and forth between you and the examiner. Examiner typically rejecting your claim the first time. It happens 90+% of the time. If he doesn't reject it, you wonder, gee, was it too narrow to begin with? And then you go back and forth and negotiate and try to get a claim allowed by adding, you make arguments as to what these words really mean in the claim. You make arguments as to, hey, the prior art doesn't show a padded seat. And he says, you have a padded seat yourself, as he has put in a second one for you to sit on. But that final, and eventually suppose you don't get anywhere, or even if you do, that entire set of correspondence back and forth between you and the examiner is called the patent file history. And once the patent application has been published, long before it's issued, that file history is publicly available and quite easy to access if you know the name of the inventor, the name of the patent, the name of the, you have to do a little searching, but it's online at the patent office, and yes, you can get it.
So if I may build on that question some more. So it does sound like that, you know, this whole process takes a significant amount of time. In your experience, what does that look like from this whole negotiated process that's to be expected by someone filing a patent?
I think I mentioned the patent office now has what they call the fast track, for which you pay extra money. They say they will get you the first response from the examiner within 4 months. And assuming you keep responding quickly, you'll reach a final decision within about a year. The more normal procedure, you're probably about 3 years until you reach a final decision. But let me add a footnote to that. In both those cases, the decision is on that particular application. If you're being simply denied and you don't want to quit, you file a second copy of that same application, and you keep arguing with him over perhaps slightly different claims. And that can keep going on. Patent Office will give you statistics as to how long it is to issue things, and actually their statistics at the moment, I think, say they do it in less than 3 years. But what they only count from is the most recent application that you filed. And if you had 2 or 3 first, where you're just beating your head against a wall, but as a judge referred to, the ant-like persistence of patent practitioners eventually won out and you got a patent, it could be a lot longer than what the Patent Office statistics will tell you.
And I guess one final sort of question for me, you talked a little bit about getting a patent here. Is it possible for students? Maybe can you share a little bit more about?
I said most students, but not you.
Yeah. So can you share a little bit more for students? Why, in your experience, perhaps share a little bit about, for students, one other pathway is to work with your academic institution to file it. Can you share more on that part?
I'm going to take 2 slightly different routes on that. Number one is, are you working under any sponsored research? Because if so, the person who's probably going to bear the cost of filing it is probably going to be the company that sponsors the research. If you're not, and it's simply an idea, you go down to the MIT TLO and look at them. Is this something they're interested in? And I think the last session on this, I very much hope to have the woman in MIT legal office whose main client is the TLO just to explain on all their stuff works. They won't work on just anything. They have to find something they think has some potential commercial value. And even then, their assumption is that MIT owns it, but that the people who want the patent are going to pay for it, the licensee. And once you get your license from MIT, you will find you can spend a lot of money getting patents for MIT under which you will be licensed, but you're going to be the person who signs those checks. It's not going to be MIT. Sorry.
So it does sound like at the end of the day, even as a student or anybody in an academic institution that you want to work with.
You have to find somebody who thinks that this is a worthwhile enterprise. Is this thing going to make, what's the goal? To make money. If you can convince somebody who has money that this will make them more money, they may well back you up. Mm-hmm. Until you get to that point of convincing them, you better either have one of very few patent lawyers who is retired and will do this basically pro bono because they like writing applications and I'm the wrong person to come to on that, or you better have a pretty damn good trust fund.
With that, thank you, Jim, for an amazing Q&A session today, and I hope all our attendees and those viewing later found this information session informative. Until the next month's IP Deep Dive, we'll see you then. Bye for now.
Bye.